The fight over pensions at Singing River Health System has moved into the courtroom, and attorneys for the hundreds of affected retirees have differing views on the best way forward. It was right around 1 year ago that the pension crisis at Singing River Health System in Jackson County first came to light. The hospital system moved to shut down its pension plan, and it soon came out that they hadn't been paying into the pension fund for several years, leaving it short millions. Since then, a multitude of lawsuits have been filed in an attempt to get the pensioners paid when they were promised. Attorney Jim Reeves was appointed interim lead trial counsel by a federal district judge in a potential class action and has been working on a settlement agreement. Reeves spoke with MPB's Evelina Burnett.
We believe that we are very close to having basically the settlement agreement papered or finalized, and we're working on language. In fact, I've been working on it all morning with both county officials and attorneys and Singing River. So we believe that we're very close to having a formal deal to announce.
How is that going to affect the pensions that the retirees have been promised? Are they going to be able to get everything that they were told they were going to get, or a certain percentage?
So what we know is that the settlement contemplates that Singing River will have to reimburse or pay back all of the monies that they should have deposited over the years, which they didn't. And so it's 100% reimbursement to the plan for all the payments that were missed. And so it puts the plan back into the position it should have been had those been timely made. And that includes payments for interest that would have accumulated in the investments during that time period. A special fiduciary has been appointed to independently analyze how to use that additional money with the money that's in there and to formulate the best plan going forward. That necessarily takes some time for him to consult with experts, actuaries, and that kind of thing to see exactly in the end how that all is to be worked out. All of that under the settlement terms is all to be supervised by the court, and any changes or modifications to the plan can only be made if they're approved and deemed fair by the court.
The judge severed some cases from the others in the Chancery Court. The cases that are severed, will they still be able to be a part of the settlement agreement if they want?
Sure. So what happens is, it's not unusual in cases this large and complex that, differing attorneys may have different theories on how to best recover for their clients. And so some attorneys in the state Chancery Court felt like, and myself included, that the settlement is the best option, and others don't. And so cases that were previously severed, when we had sort of compatible ideas about the case, were just separated so that they can sort of go their own way and we can go ours. But a settlement in the class action, all pension members will have a chance to participate, or if they think it's unfair, to object to it as well. And so all that's contemplated, and what happened yesterday is not really unusual in cases of this nature.
Well, I guess part of the disagreement has been in terms of the discovery, with some of the attorneys saying that they haven't been given access to the documents and people to interview or depose. What are your thoughts on that in terms of what kind of access have you received?
We've had everything that we've requested produced and provided, and in fact, a huge volume of documents. So we early on requested expedited discovery and production of key documents that were aimed at doing a couple of things. One, helping us determine what payments were missed and what was owed to the trust. Two, what was the current financial situation with regards to the trust. And three, what the hospital's ability to repay the payment was. And so we've gotten all the discovery we felt like we needed and requested. In fact, we've obtained somewhere in the neighborhood of 120,000 pages of documents that have been produced. We have had our written discovery requested. We've obtained other documents from subpoenas issued to the county court. And so for our purposes, at least in terms of the hospital itself and the county, who would be parties to the settlement, we feel like we have the discovery we need to complete that phase of the case. Now, that being said, there are other entities out there who had roles in either managing the investments over the years and that sort of thing, who we believe probably are going to owe some additional money too. So we would anticipate having additional discovery against those individuals or companies in the future.
MPB's Evelina Burnett with attorney Jim Reeves.